I assume we've called the absent members. Not quite at a quorum here, but why don't we give it about 2 more minutes, and then we'll start as a subcommittee. I see we've got some authors, and we'll get rolling here. She was here a second ago.
Yeah, she's right over there on the left with Mindy.
Oh, okay. Senator Wolk, do you want to go ahead and begin? I wish I had more members here for you, but you know the drill. Welcome. Take your pick.
Let's do 1173.
All right, recycled water.
Mr. Chair and members, 1173 will expand.
I'm sorry.
Press the red button.
I'm very sorry.
It's okay. Good morning. 1173 expands existing law to promote the use of recycled water in place of raw water for non-potable uses such as industrial cooling and landscape irrigation. 1173 maintains the current process, the process under existing law that the State Water Resources Control Board is responsible for determining that recycled water is of adequate quality and availability for the intended use and of comparable cost to sources of raw or potable supply. By maximizing the use of recycled water, this will ensure that we stretch our limited water supply for maximum benefit and that communities will limit the need to divert more water from fragile water systems, like the Delta. I ask for your aye vote.
All right. I think this sounds like a great bill, Senator. It seems to me you've got one issue that continues to need a little bit of work, and that's ironing out a definition of remediated groundwater. Is that right?
I believe we did that.
Oh. Oops.
Yes, we took an amendment.
I thought we
but
took an amendment.
It is not defined in code is the issue.
Ah.
But the state board, we've talked with the state board, and they think that's okay.
Okay. Well, we're certainly willing to continue working with you.
Okay.
I know that the committee staff in the Senate also has some interest in that, but I think that's
fine.
easy enough to resolve.
All right.
Thank you, Mr. Chair. If I may, when the time is appropriate,
Please.
I'd be happy to move
It's
the bill.
just us here.
So for you.
We
Right.
can't-
Thank
we
you.
can't do
I know
that
we can't
yet.
do anything, but we will when the time comes. Thanks.
And I'm also advised that I actually initiated our proceedings this morning without a Republican present, which I should not have done. So
Sam is here.
so I don't know quite what to do.
We'll do it again.
You were
When we
great.
come- I'll do it again.
Yeah. The sequel.
This time I'll mention the Aqua Amendment.
I would love to wrap this up and also jump on to your next bill, but I think as a courtesy and in deference to our custom here, I should give it a couple more minutes
It's
and at
fine.
least get a Republican present. So thanks for your understanding.
what we'll do is if this ever comes before us, we'll have to decide what remediated groundwater is, rather than taking.
So basically Jared is saying he wants that worked out before.
Well, we've been working with DNR to figure out how to deal with it, because otherwise we're going to have a list of definitions in the law, and we just have to work that out. I think remediated groundwater. This code just applies to recycled water, and remediated groundwater should probably be defined in the current water code.
Before it goes to the floor.
I think we can do that. We can work with this staff and then ESTM. ESTM probably has
Yes.
environmental safety and toxic.
Oh, double refer?
Yes.
Okay.
So that's why I figured we would be working on that and that commission.
Tell me all now. I'm just saving a little time here.
And we could make a dent in it.
It only came up after.
Either that or the
Okay.
came in.
Let me just go tell them.
But no,
It is 9 o'clock in the morning.
people wonder why our approval rating is 90%. It's okay, I may not have been here very long, but I've been on the planet for about 6 decades. Understood. So, at this stage of life,
Now that I'm awake.
Waiting for a Republican.
already?
Oh, I have it here.
We called all the Republican
Yes, sir.
No, at 10.
Is this a boycott of some kind?
I'm aware of.
They slept in.
Hopefully.
We had a wolf built by Miss Wolf. And got taken off, so they may have decided.
Stormed out in the house.
Yeah.
Oh. Welcome, Chief.
All right, Vice Chair Fuller is here, so we're going to begin as a subcommittee. Again, we had a little false start where Ms. Wolk gave an eloquent presentation on her bill, but we had to rewind it because there was no Republican present. So we're going to ask her to do a dramatic rereading.
Mr. Chair and members, 1173 will expand an existing law to promote the use of recycled water in place of raw water for non-potable uses such as industrial cooling and landscape irrigation. We have accepted amendments that address Aqua's concerns. There are still some issues that remain. We are double referred, and we'll work those out as we get to environmental safety and toxics. To maximize the use of recycled water is a good idea for California. Let's stretch our limited supply for maximum benefit and for communities. I ask for your aye vote.
Very good. Do you have any witnesses in support, Senator Wolk? Any witnesses wish to appear in support? Come on up. The microphone on the end is fine. You may need to push the button there.
Thank you. My name is Jason Kandra. I'm with the Planning and Conservation League, and we support this bill.
Thank you, Jason. Any other witnesses in support? Witnesses in opposition? All right, seeing none, questions or comments of the committee? All right, yes, Vice Chair Fuller. Thank you.
Now that I have arrived, and after I wake up. Mr. Solario is the author of AB 1834, the Rainwater Capture Act of 2010. Within the definition of raw water contained in Section 2 of your bill, do you anticipate that the impacts will be on the development of these rainwater capture systems? did you change any, is the raw water term still in your bill? I don't know what your amendments were.
I had not.
Water's the
Yeah. Does it exclude cisterns and catchments?
Well, yeah, raw water is like a new term that's like not been litigated over a period of decades like normal water, and so I'm concerned whether rainwater is generally considered surface water, or would it would it be a waste and unreasonable use under the changes contemplated in her bill? It's just not very clear to me how it's all going to work together.
You know what?
I don't believe so.
I think Assemblymember Fuller has hit on a nice catch, actually, because I read the definition of raw water, and it probably does need to exclude cisterns and catchments, because I don't think that's the intent of the author.
No.
To force a
Nope.
major repiping to recycled water. When
Yeah, absolutely.
Yeah.
That's the first problem, and then I think the second problem is just that because it's a new term, it seems like it might be better to use some term that's already been litigated 100,000 times in the last 100 years, like water law all seems to be. Otherwise, I'm just a little worried that we're going to end up with the Full Employment Act for water attorneys
Well, we
based
already
on
did that last year.
yeah, based on adding a new term. So while I think some of the ideas are good. I'm just a little worried about some of the vocabulary, and I'm wondering is there some way we can adjust that to make that? Is there existing vocabulary that might
rainwater catchments.
serve us well?
Ms. Fuller, what I would do with the chair's permission and the committee's, it is double referred. This is an issue that is new. It is not our intent to include cisterns and catchments. And if there is something else, I'd be glad to work. Anything else in terms of definition that is unclear or of concern, I'd be glad to work that through the committee and the committee chair.
Okay. Well, I'll be withholding my vote until we get through that, but I appreciate your willingness to work with that. And if we can find some other terms that are more vetted, I think that'll be very helpful. Thank you.
Well, and I appreciate you flagging the issue. It's hard to imagine anyone ever approaching an individual homeowner or business and forcing them to switch to recycled water because they are using a cistern or catchment. But why not go ahead and make the clarification at the front end? And so I hear the senator expressing a willingness to do that.
Yeah.
Great.
Okay.
Any other questions or comments from the committee? We now have a quorum, so if you'll indulge us while we establish that quorum, we'll proceed to a motion.
Huffman,
Present.
Fuller,
Present.
Anderson, Arambula, Berryhill, Blumenfield, Caballero, Delatorre, Fletcher, Lowenthal, Salas, Yamada. We have a quorum.
All right. Do we have a motion?
I'd like to move the bill, Mr. Chair.
All right. Motion by Ms. Yamada, second by Mr. Rambula. Please, would you like to close, Senator Wool?
Just ask for your aye vote. Thank you.
Very good. Let's please call the roll.
Do pass to Environmental Safety and Toxic Materials Committee. Huffman,
Aye.
Huffman, aye. Fuller,
No for now.
Fuller, no. Anderson, Arambula, Arambula, aye. Berryhill, Berryhill, no. Blumenfield, Caballero, Caballero, aye. Delatorre, Fletcher, Fletcher, no. Lowenthal, Salas, Salas, aye. Yamada, Yamada, aye.
Okay. It's on call. That bill is on call. Senator, do you want to go to 1303?
Yes. This is a bill about accidental take. 1303 will authorize, actually it's the result of a stakeholder agreement that we'd like to highlight. It will authorize nonprofit agricultural associations to develop and conduct public outreach program about the importance of habitat conservation.
All right. I have a motion and
The
a second.
department, okay.
Please continue.
Department of Fish and Game is authorized to approve applications submitted by the nonprofit to initiate and undertake public outreach, and the bill then will extend the sunset on the accidental take provision to allow implementation of these outreach programs. This is a good bill that's the result of good negotiations co-sponsored by the Farm Bureau and cattlemen's, and no known opposition at this point, and no votes. I ask for your aye vote.
Very good. And you have some witnesses in support here.
Good morning, committee members and Mr. Chair. Noelle Kramers with California Farm Bureau. I'll try to be very brief. Farmers and ranchers throughout California provide a significant amount of habitat for wildlife, but often this comes with additional regulations if those species are listed, and the accidental take and incidental take provisions under CISA provide very important protections for landowners. We sincerely appreciate Senator Wolk for carrying the legislation and appreciate all the stakeholders working with us to come up with amendments to allow us to extend the sunset to 2014 in return for conducting outreach to our members. Any nonprofit organization can apply to conduct this outreach to increase education and understanding about the incidental and accidental take programs.
Thank you.
Dawn Clover with California Cattlemen's Association. The continuation of the sunset is, with the public outreach component, we feel will be beneficial to protecting habitat on grazing land, specifically for my membership in the future. So we ask for your aye vote.
Gail Delahant with Western Growers Association. We support the bill. Thank you.
Mr. Chair and members, Dan Taylor with Audubon, California. I want to thank Senator Wolk for her leadership. We were initially opposing the accidental take sunset extension, but through the discussions that we've had with the author and her staff and stakeholders, we believe we've discovered a proper and appropriate solution for going forward. We value the role of agriculture in protecting and stewarding the California landscape for wildlife. And while we're prepared not to oppose an extension to the sunset within 1303, we believe that seeing the real progress toward additional measures of education and outreach are critical milestones, and we'll look forward to working with stakeholders in the agricultural community to ensure that those efforts are effective so that in 3 more years it will no longer be necessary to come back for an accidental take extension. With that being said, we're pleased to report our neutral position on the bill. Thank you.
Valerie Nera for the California Chamber of Commerce. We are in support of the bill.
Hi, Mr. Chairman, members of the committee. Mark Henley with California Outdoor Heritage Alliance in support. Thanks.
Thank you, Mark.
Karen Keene on behalf of the California State Association of Counties in strong support. Thank you.
All right. Any other witnesses in support? Any opposition to this bill? Seeing none, we'll go to the committee. Yes, Assemblymember.
Yeah, I'm curious. I'm going to be voting for this bill, but the Republicans on the Senate side, you had a number of not voting. Were they just not there that day, Ms. Walk?
Trying to remember. Susan?
Okay, because this seems to me a pretty easy vote for us, and I'm certainly going to be going on for it. But I was interested in why there was some extensions, and I thought, well, maybe they just didn't show.
I don't know. We've had a hard time with attendance over the past few days. Have you had the same problem?
Yeah. Well, I'll be going up for it.
Was it during duck hunting season?
Duck hunting season also? Yes. That's right.
Any other questions or comments from the committee? Senator, I want to thank you for this bill, and particularly for the way that you've styled it, because I think, as one of the witnesses said, none of us want to play gotcha with CISA on agricultural operations, but I think good policy needs to take us towards something better than a series of blanket exemptions for accidental take. We need to get people into the safe harbor programs, into HCPs and other mechanisms that can address their legitimate needs and give them protections from take problems, but also do right by our endangered species laws. So I think this is a good compromise, and happy to support it. So would entertain a motion. We have a motion and a second already, so let's call the roll. Yeah, I assume that you want to just request an aye vote.
That was my close. I request
Perfect.
an aye vote.
Thank you.
Do pass to appropriations. Huffman?
Aye.
Huffman, aye. Fuller?
Aye.
Fuller, aye. Anderson? Arambula? Arambula, aye. Berryhill? Berryhill, aye. Blumenfield? Caballero? Caballero, aye. Delatorre? Fletcher? Fletcher, aye. Lowenthal? Salas? Salas, aye. Yamada? Yamada, aye.
That bill is out.
Thank you.
Senator Annisted, thanks for your patience. You're next. Good morning.
Good morning, Mr. Chair and members. I'm pleased to present SB 899. As you remember, last year, the legislature and the governor signed into law a ban on suction dredge mining in the state. That occurred early in the month of August, about midway through the season for this kind of mining activities, which is largely a recreational activity and an important part of the economy of my district. People buy permits, in-state and out-state permits, $47 for an in-state permit and $135 for an out-of-state permit. These permittees were not able to utilize these permits after August 7th or 6th because of the urgency measure of the clause, and yet the California Department of Fish and Game had no authorization to be able to make refunds. That's all that this bill does. SB 899 allows Fish and Game, upon the request of each individual permittee, to have their refund made to them for not being able to use their permits from last year. I have Pete Conity with the 49ers who are sponsoring this bill as my witness.
Good morning, Mr. Chairman, members. Pete Conity. I represent the new 49ers from Happy Camp in Siskiyou County, which is a recreational gold mining and suction dredge organization. And we would respectfully request an aye vote.
All right. Well,
Hi, Cindy Hillary, Regional Council of Rural Counties. Much of this activity takes place in the 31 rural counties that we represent. It represents a fairly significant portion of income to local businesses, especially hotels and the types of stores that sell this kind of equipment. And we recognize this as just a matter of fairness to refund these permit fees that many of these people didn't even get a chance to use at all. Thank you.
Thank you, Mr. Chair. Members, Tom Renfrey on behalf of the Board of Supervisors of Siskiyou County in support of the bill.
Mm-hmm. Senator, any other witnesses in support? Any witnesses here in opposition?
I'll move the bill.
Okay, we have a motion. Let me ask first, the committee has requested an amendment. I think the word fairness is used, and there was a period of multiple months where these permits were usable before the legislation took effect, and so the committee has suggested a 2/3 across-the-board refund instead of a 100% refund. What is your position on that amendment?
I appreciate the amendment. This was fully discussed in the Senate process, a very lengthy discussion. The $47 fee, it basically is not cost effective for a state official somewhere sitting at a desk to figure out what proration should be going on with each of these permits. Many of these permits were not even able to be used because vacation had not occurred, school was not yet out. The season extends and is most heavily influenced at the end of August and September and October. The cost and the time consumed for a $47 permit for each one to be looked at, we just felt was not cost effective. Not only that.
Well, just if I might clarify, that's not the amendment the committee is suggesting, that somebody look at each individual permit.
I understand.
The committee is suggesting an across-the-board 2/3 that would require no staff time.
It's an arbitrary number.
Right.
And I suggest that a more fair arbitrary number would be 100%. Because the folks that are engaged in this activity don't just buy a permit. They spend thousands of dollars in purchasing equipment that they could not use. We had significant revenue losses to many of the businesses, and I think that it should be incumbent upon the state to be fair-minded with its citizens, that if it's going to pull a permit in the middle of the year and not give them adequate notice, to not spend that money to invest in the activity to begin with, which can be up to $10,000 to $12,000. I really think that what's really fair is just to refund the $47. We're talking about a total of no more than $250,000 if every permittee were to request this. And this is not just instructing the Department of Fish and Game to do this automatically. Each permittee has to request the refund. And so assuming that is 100% request, which I don't think would happen, we're still talking $250,000, and I think that's what's fair.
All right, Assemblymember Caballero. Yeah.
Thank you, Mr. Chair. I just have some technical questions, and I'm sorry if I've just got it wrong. But let me ask some questions in regards to when this fee is available. And I appreciate the comment about the Senate, but Senator, this is the Assembly, and we give thorough hearings to these issues. And so I appreciate that it may have been discussed in the Senate, but this is the Assembly. I am assuming, and correct me if I'm wrong, that the fee is a yearly fee. You get it in January and expires in December. Am I incorrect in that?
The Senator has allowed me to answer. You can buy it in January. You can buy it on December 30th. The permit runs from January 1 to December 31, regardless of when you buy it. The season goes from July to September.
Okay.
These permits were cut off in August. So half of the regular season for suction dredge gold mining was lost. And anybody that wanted to take a vacation for a week or 2 weeks and go do suction dredge mining and had bought a permit lost the full use of that permit for a whole year. It seems to me that if we're going to get into
thank you for answering my question, because the second question was when the peak of the season was, because I'm just trying to get an understanding of if we're going to assign a number. And I'm in support of the bill. I'm just not in support of 100%. And number one, number two is that
when the water is warm, and that occurs in August and September and October.
That's what I figured. I figured it's the summer months.
But it's technically one can suction dredge in certain places year round, right?
Starting. Well, I don't know what there's a. It depends on the river.
The regulations are different for different rivers at different times.
They are, but very few people suction dredge. Most of our gold, placer gold, is located in the north, in the Sierras and the mountains in the north, in the rural counties, along the Kern River and other rivers, and most of that is done during the summer months.
I didn't mean to interrupt, Ms.
No. That was one area I was. Yeah. As we're assigning a number, I wanted to understand a little bit better what the time period is. Where obviously if the permit was issued along our own budget calendar, I'd feel entirely differently about it. So I appreciate that opportunity. The other question I guess I have for Fish and Game, and that's in regards to, to me it's once we figure out what the amount is that should be refunded, it's a computer punch as far as I can see. So I don't. The time and energy consumed, but I can ask that of Fish and Game later. So I do appreciate it. Thank you very much.
Okay. Ms. Salas, you had a question?
Yes, I did. In the analysis, it does state that there's a question as to whether or not the bill is necessary and that the governor has the authority to issue these types of refunds, and he can do so as by way of executive order, and he's done that in the past. And so, was there any communication with the governor's office regarding this problem before this bill was introduced?
Yes, the governor has done this in the past when an emergency declaration was made concerning a natural disaster. This did not have that emergency declaration. The governor then was not inclined to issue an emergency declaration, simply to issue refunds. That's why we're here before you folks, because it now takes a legislative action to allow the Department of Fish and Game to do this.
And in the analysis, it states that it wasn't clear whether or not the governor had that emergency authority anyway, and he was able to issue that declaration or that executive order that allowed the refunding of it without there being a clear emergency. So again, the question is whether or not that was discussed with the governor.
Not specifically with the governor, but with the governor's staff. And now you're asking me a question. I'm not a lawyer, so I can't really answer that question as far as whether he had the legal authority to do it. All we know is the only time that he has done it has been in conjunction with a natural disaster where he declared an emergency.
Thank you.
All right. Other questions of the committee? Mr. Brayhill.
Yeah, I do. This seems like a pretty easy yes vote for me. We've got people that have come in. We've got the government that have taken away an opportunity for them. This has happened historically in the past, that where the government has come in, taken something over, and given refunds. So I think you have President on your side. I think you have history on your side. I think this is an easy aye vote, and you got mine.
Okay, so Assemblymember Fuller has moved the bill. Do I take it, Assemblymember, that your motion is 100% refund? Yes. Okay.
That I'd like a question.
Okay, and then...
So, first of all, as I remember, we cut off this industry without warning. There was no way that the consumer could or should have known that if they bought this permit, it wasn't going to be good. Is that true?
Without warning?
Well,
I mean, we had bills for 2 consecutive
it
years.
doesn't count if it hasn't passed before. In fact, if anything, in my constituency, they would think that means it's not going to pass. But I have to say that, embarrassing as it is, I did vote for this bill. I did want this bill, and I supported this bill. However, I've been besieged by people who are unhappy, and I have to say that in the school teacher sense of that I have. When they tell me that they couldn't have known and they bought this permit in good faith and then they lost their money and they lost their equipment and they lost the interest on the money, even though I think, it's a good thing. I think maybe the timing with which we did it was difficult for some. So one, I'm just trying to say that I think that they couldn't have known. Number two, I wanted to know if there has been successful litigation because this particular constituency is adamant about things. I mean, there's a $16 difference. All we're going to save is $16 per person based on a 2/3 difference, and that, I think, would make some of them very adamant. And so have they successfully sued us over their $16 or some litigation in the past?
Yes, they have, and I'll let
First of all, for the record, my client is not interested in a 2/3 settlement. 100% or nothing.
Okay, I understand that. But have they successfully sued?
We might have some say in that as well. But
Have they successfully sued in the past?
Yes.
Okay, and has it cost the government a little or a lot?
There is a case where it was taken to small claims court, and maybe Fish and Game can elaborate on this, but Fish and Game is required to send an employee every time a claim would be entered into small claims court. In this particular instance, Fish and Game was required to send an employee 3 separate times before it was resolved. I believe the Attorney General also sent a lawyer to represent Fish and Game, as was told by the judge that he could not represent them. It had to be someone from Fish and Game, and the judge in the small claims court gave full restitution for the full amount of the permit without worrying about when it was issued. And so the prospect is that we have brought this bill forward in a good faith effort to avoid having 2,000 to 3,000 people go to small claims court to get their money back. We have one organization in the Bay Area of 400 members that is actually anxiously awaiting the outcome of this committee hearing.
Thank you.
All right, I have Ms. Yamada, Mr. Rambula, and Mr. Fletcher.
Thank you, Mr. Chairman, and thank you, Senator, for bringing this bill forward. You mentioned that this was a matter of fairness, and while I understand that these permit holders who have probably been holding permits for, I don't know, what's the average number of years, would you guess? A decade or more, maybe, Mr. Conant?
Well, actually, many of them, it was quite a tourism industry.
Mm-hmm.
When the first bill was introduced by then Assemblywoman Wolk, we had letters from all over the United States and from foreign countries of people that came to California specifically for this.
Mm-hmm.
But in order to do it, they would have to buy a year-long permit, even if they were just here for a week. So, in fact, the majority of the permits are not held. There's a small group of people that do this for a living, but the majority of them are recreational.
Mm-hmm. So in purchasing a permit that would become available at the beginning of January and good for the calendar year, there is some sense and good faith and reliance that they might not be able to use it for the full 365 days. It's really a seasonal permit for an annual fee. Would you say that was a fair characterization?
I would say that's a fair characterization, but I'm really not sure what you're trying to get at, because if the season's 3 months long and you know you're going to be taking care of the season, you buy your permit in January, or you wait till June or July. I'm not sure what difference that makes, because what about fishermen? Should we start prorating their licenses when they purchase them based upon when they're going to go fishing?
Well, actually, what I'm getting at, Mr. Conity, is that I think that in terms of fairness, if the permit is available year-round and there's been cancellation, if you will, or a moratorium placed on this activity, actually only until, the fall of 2011, when the environmental impact report emanating from Senator Wiggins' bill is supposed to be ready. We're talking about maybe 2 or 3 months out of a year-long period that you are now asking for 100% refund. And it just seems to me that, a two-thirds, which would, require an Excel spreadsheet perhaps, and I think was referenced by another member, would take maybe one button to calculate. It would not be that difficult. So what I would like to say is I will not be able to support 100% refund today, but would certainly be willing to entertain a partial refund for these folks. Also, I think we need to look at the aegis of the moratorium. The moratorium is intended to look at maybe the costs that are being created by this activity. And $47 for in-state and $185.25 for out-of-state, compared to the as yet unknown costs of environmental damage to the rivers with suction dredge mining. I think a two-thirds compromise would be something that I could support. But that's all I have to say, and thank you. I don't know if you have any response to that.
I respectfully disagree. But if you want to get into it, the environmental damage is from mercury, and the jury is still...
Let's not go there. Let me go to Mr. Arambula.
Thank you, Mr. Chairman. Senator, just to let you know where I'm coming from, if it's 100% or nothing, I will vote nothing. I, however, am aware that suction dredge mining was allowed up until August 6th. So I think there was, in terms of fairness, I think there was some usable period for the permits. And rather than consume a lot more time here at the hearing or consume time having the agency figure out what's the correct split, I would support the two-thirds. I think that's fair for all concerned.
And before we go to Mr. Fletcher, let me just say that the chair would, certainly I'm going to oppose the motion that's been made, but I would welcome a substitute motion after that's been voted upon to reflect the two-thirds amendment. So why don't we go to Mr. Fletcher?
Thank you. Mr. Chair, when this bill came up, it was such a pressing problem it required urgency. And overwhelming majorities of both houses passed it and the governor signed it. If we'd gone through the normal process, it would have taken effect January 1 of the following year, and this issue would be moot. But it was such a pressing problem that required urgency, and it seemed like we could apply some level of the same sense of urgency to taking care of people that were affected by this bill. They not only lost their permit money, they lost what they did for recreation, what they did for fun, they lost their equipment, they lost their travel plans. And that's all fine because this body and a number of us went along with it, said this is such a problem, we're going to intrude on your right to do this. But it would seem like the least we could do is give them their $47 back. When you buy a permit, you buy it consistent with current law, and you make an assumption that if you're selling the permit, that permit will be honored in good faith. And so if we'd passed it with the normal taking effect January 1, then the next year they would have known not to buy a permit. But when you change the law midstream, then the whole point of buying the permit was pointless, right? But you didn't know that when you bought it. So unless we're going to go back and ask each person who bought a permit, how many times were you planning to go? And then how many times did you actually go and get into their head about what their plans were going to be? That would be the fair way to do it if we want to go person by person by person and ascertain that, but we can't. And it would seem like when we've taken action to deal with a problem, whether real or not, it's happened, it would seem like the least we could do is give the people that spent $47 to do something they had been doing year after year after year their $47 back. It just doesn't seem, I mean, that seems like an issue of fairness. And so I support your bill 100%, and I think we're spending a lot of time on what's fair when at the end of the day, this body took away someone's right to do something. They had purchased a permit consistent with what their right was at the time, and it would seem like the least we could do is give them the $47 back because they acted in good faith. They didn't know. So I support what you're doing, and I look forward to supporting this bill, and I hope it has success.
Mr. Anderson.
I don't know if anybody here can answer this question or not, but when they applied for the permit, were they given any notice that there was a chance the permit would be yanked from under them, and that so that they could make choices in their life? I mean, you know, it seems to me we didn't properly notify them that this opportunity could be yanked from under them amidst the middle of the season. So if we had noticed them before, I'd feel more comfortable with the 2/3. But since we didn't notice them, I want to be fair to them. I mean, they've made all this commitment of getting their equipment there. They made all the commitment of making their travel plans and all the rest. And then to be $47 hardly compensates them for what happened. So.
There was no notice, nor do I believe DFG would legally be able to give notice, hey, there's a bill in the legislature that might mean you don't get to use your permit. I mean, if we started doing that, there'd be a lot of notices going out.
All right, we have a motion. I want to remind everyone who's been on this committee for a few years that this is not a new issue. It's been before us every year, I think, that I've been here. I think anybody who was remotely engaged in this activity, in this avocation, has known that there's a controversy, there's been litigation, there's been a regulatory fight with the Department of Fish and Game, and there's been proposed legislation that ended up in final legislation. So the idea that this somehow caught anybody off guard is a tough one for me to swallow, but I want to remind everyone that the committee is proposing to refund 2/3 of the annual permit fee for a permit that was available and usable for 8 months of the year. So it seems to me like a fair compromise, but with that said, we've got a motion to refund 100%. I'm recommending a no vote on that. Senator, do you want to close, or can we proceed to the vote?
2 weeks ago, my wife and I went to a movie, and 15 minutes into the movie, we didn't like the movie. We walked out and asked for our money back, and the manager gave us a full refund. He didn't prorate it for the 15 minutes because he knows that's good customer service, and that's really fair. We're talking $47 to the citizens of this state. You say 2/3, you say 60%, you say 50%. It's all arbitrary. The only really fair number here is 100% for $47. And if you're going to withhold your vote because it's not $47, you want 2/3 of $47, you're answerable to the people who elected you. I appreciate the discussion. I think it's much ado about nothing, but I welcome the conclusion of this.
All right. Thank you, Senator. Please call the roll on the motion.
Do pass to appropriations. Huffman?
No.
Huffman, no. Fuller?
Aye.
Fuller, aye. Anderson?
Aye.
Anderson, aye. Arambula? No. Arambula, no. Berryhill? Aye. Berryhill, aye. Blumenfield? Caballero? Caballero, no. Delatorre? Fletcher? Aye. Fletcher, aye. Lowenthal? No. Lowenthal, no. Salas?
No.
Salas, no. Yamada? No. Yamada, no.
All right, Senator, that measure fails. I will entertain a substitute motion at this time.
Mr. Chairman, if I may, I would be pleased to propose a 2/3 refund of the fees that we had just discussed.
All right. Is there a second? All right. We have a motion and a second. Do pass with a refund of 2/3 as recommended in the committee amendment. Please call the roll.
Can I close on that?
No, sir.
Huffman?
Is this a hostile motion?
Only if you make it so.
No, I'll pull the bill first, please. I don't.
There's a motion and a second pending. Please call the roll.
Huffman?
Aye.
Huffman, aye. Fuller? No. Fuller, no. Anderson?
No.
Anderson, no. Arambula? Arambula, aye. Berryhill? No. Berryhill, no. Blumenfield? Caballero? Caballero, aye. Delatorre? Fletcher? No. Fletcher, no. Lowenthal? Aye. Lowenthal, aye. Salas?
Aye.
Salas, aye. Yamada? Yamada, aye.
All right, that measure is on call. Thank you, Senator. Welcome, Senator Hollingsworth. Who was first? Oh, I apologize. Senator Simidian was behind you. I didn't see him there. So. Good morning, Senator. This is SB 21.
Thank you, Mr. Chairman and members. In March of 2007, the Governor's Ocean Protection Council unanimously approved a resolution on preventing and reducing marine debris. This measure responds to the issue that was raised in one of the issues, at least, that was raised in that resolution by requiring the Department of Fish and Game to include a toll-free number and internet website on their various fishing licenses and brochures by 2011 so that people will know where to report abandoned fishing gear. Also authorizes the Ocean Protection Council to work with the Dungeness Crab Task Force to develop recommendations to identify the source of derelict fishing gear, and further would authorize the Ocean Protection Council to develop procedures that would allow the fishermen to keep the derelict gear on board that's recovered during their normal fishing operations, rather than throw the gear back into the ocean because of concerns that they might be cited for improper gear out of season. The history on this very modest measure is that the governor vetoed previous legislation, Senate Bill 899 that I authored last session, which was more comprehensive, would have required a sort of more robust reporting of derelict gear, set up a database, required that traps and trawl nets be tagged or coded. And the governor's veto message essentially was, well, I can read the veto message. He said, the governor encouraged me to develop a program that, quote, does not rely exclusively on government funds and employees for this effort, end quote. So the message we've got from the Ocean Protection Council is, big problem, let's get on it, let's do something. The governor's response essentially was, yeah, but we got no dough, so we got to find a way to do this on a voluntary basis and using nonprofit folks where we can. So this scaled-back bill addresses the concerns raised by the governor, designed very simply to enable the voluntary efforts of nonprofit groups and fishermen across California. It's an economic issue as well as an environmental issue, and we will be following through the meetings recommended by the governor. There was opposition to this bill when it contained all of the sections of the old bill. I'm hoping that the fact that it is stripped down now means there's no opposition. That's it.
There's a motion and a second. Anyone here in support of this bill? Any opposition?
Good morning. I'm Julie Altman, Department of Fish and Game. We're not in opposition to the bill. I want to be clear about that. We were opposed to a prior iteration of the bill and had conveyed to the senator at the time that we were certainly willing to do pretty much everything the bill had asked. And in fact, we have put a link on our website to report lost fishing gear. We also included the information about reporting lost gear in our regulation books. I have a couple of black and white copies. We don't have a color printer. So a copy of the reg book as well if you'd like to see it. As far as putting the reporting information on a fishing license, we're more than willing to look at that. Currently, we're switching to an automated license database system to issue the licenses on Tyvek, and we're more than happy to look at putting that on as well. I think the message here is that the department agrees that derelict fishing gear is a huge problem in the marine environment, and we're trying to do everything we can without expending new resources to get there. So we kind of consider this already addressed. I can't speak to the Dungeness crab task force provisions that were just put in the bill, but otherwise I think that we consider this something that we already are concerned about and working on.
Senator, did you want to respond to that?
Delighted to hear it. Want to make, there's really two elements to the bill, members. One is I work on the theory that if you want somebody to do something for you, you should make it easy for them to do it. Whether it's vote for your bill or do something about the problem with the derelict fishing gear. So what we want to be sure of going forward and beyond this particular administration or this particular group of individuals is that if there's a brochure or a fishing license, the thing that people are actually likely to have, that there be easy to access information about what's the phone number and what's the website if you want to do something about the problem, going along the lines that the governor suggested of trying to enable people to do things on a voluntary basis. The second part, so I'm delighted to hear it. Really all the bill then would do is say, good efforts underway, glad to hear it, want to make sure that they continue to be part of the way we do business and that we don't lose this, because as I say, it's the way we enable people to self-help on a volunteer basis. Second part of the bill goes to Ocean Protection Council and says, we'd like you to look at ways in which people can be more successful voluntarily. One of the problems we've got right now is if you come across some of this crud in the ocean, forgive the technical language, and you haul it on board, then the question is, what do you do with it? And the answer is, you may not want it on board because someone may come along and say, we're going to cite you because you're fishing out of season or in the wrong place. And the way you avoid that is by creating some sort of protocol that would make sure that folks who are trying to do a good thing on a voluntary basis are not going to be penalized for that, don't feel that they're at risk, and don't have some incentive, which they do now, to just say, let's throw it overside and pretend we never saw it. So those are the two elements of the bill. As I said, I think it's an undeniably modest bill. On a 0 to 10 scale of significance, I give it about a 1.25. But it is a modest step. And perhaps I'm bragging even at that, Mr. Berryhill. But I think it is a modest step towards this problem, which we know is huge, which we know we need to tackle, which we know we don't have adequate funding to tackle with state funds right now. And it's a way to step in the right direction.
Senator, I think I've heard you say you have two kinds of bills, simple and landmark.
Well, what I've said is that legislators typically have two kinds of bills. When they're presented, they're simple little bills, and when they're in our press releases, they're landmark bills. This one will not fall in that category under any set of circumstances.
I look forward to the press release after its passage, actually. Any other opposition or other positions for the record? Questions? Yes, Assemblymember Fuller.
So if I understand it, there's one I would like to address, Fish and Game. So why wouldn't Fish and Game allow people to pick up abandoned gear and dispose of it? Is there any circumstance you can imagine where you wouldn't allow them to do that?
I have never heard of any fishermen complaining that they were concerned that we would cite them for possession of illegal gear, off-season gear, and then they returned it to the ocean. I've never heard of that.
Okay, so that's one part. And then the other part of the bill is, I understand now the CDOC Society has, for the last 5 years, with worked with the California Coastal Conservatory, the Scripps Institute, and the California Department of Fish and Game to do just this on a partly funded by private or voluntary funds, and I'm not sure why that isn't enough and why that isn't working at a time when we're kind of strapped for funds here. And after all, I just saw us not be able to give $16 back, so I'm concerned about spending even one more dime.
Well, as far as CDOC, the department regards CDOC as a great partner in this effort. If you Google lost fishing gear, which I did this morning, you find links to CDOC. That's pretty much the only game in town in California at this point. There are some other efforts. We're welcome to work with them as well. The department has supported efforts in the past for CDOC to procure money both from OPC and from the Coastal Conservancy itself to run their lost gear retrieval efforts. We're willing to partner with them in any way we can. We also partnered with Boating and Waterways to set up receptacles on docks to dump lost, old fishing line and that other sort of lost gear. So in the absence of funding, which I think we all know is sort of the elephant in the room in terms of really addressing the problem, we feel like we're doing what we can.
Thank you.
Through the Senator, just to respond to the question that Assemblymember Fuller raised, the problem as we heard from the industry, and I represent San Mateo County and Santa Cruz County, which is on Monterey Bay, so we have a still significant, albeit struggling, fishing industry along those two coasts. And what happens, particularly if you're trawling, for example, you're going to pick up this marine debris. And the problem is that the way licenses are issued is you get a particular license for a particular set of dates for a particular kind of gear to be fishing for a particular take during that particular season. So the issue then is what happens if you drag something up, as often happens, it's on your deck, and now the question is if you get stopped by somebody, you're essentially sitting there looking like you are guilty of fishing with the wrong kind of gear in the wrong season and the wrong dates, and this is an issue that has been raised by folks in the industry with me. So if it's not a problem, the fact that we authorize the Ocean Protection Council to sort it out shouldn't be a big problem. There's no real requirement here, just a sort of a gentle nudge in the right direction. But I think there does need to be a clearer protocol so that people are risk averse under any set of circumstance, and they're particularly risk averse if this is essentially a volunteer good deed. So again, if we want people to do something that we think is good, we ought to make it as easy as possible to do it. And in this case, easy as possible means eliminating any potential concern about violation for the kind of gear in the season and the take.
Just by way of clarification, maybe from the department, isn't it illegal to have certain gear on your boat or on your deck during certain times?
Yes.
So I think that's the problem, is that if people see some abandoned gear that's illegal for them to have on their boat, they're unlikely to take it onto their boat, even if they're trying to be good Samaritans and clean up a mess. So
yeah, and if the case were
that would be usable gear, though, wouldn't it, Mr. Chairman?
Usable gear?
Usable gear. So if you're picking up just garbage out there, it would seem to me that you're not going to get cited for that, are you?
Well, that was going to be my point, is that if the warden can tell that this is really truly derelict gear and it's corroded and it still happens to be killing fish, but it's still degraded, we would certainly not attribute that gear to that fisherman.
So it would be irrelevant.
Viable fishing gear.
That'll be your next bill, Senator Simidian.
Right. Did you have more, Assemblymember Fuller? No. All right. Any other questions, the committee? I think we have a motion and a second. Would you like to close, Senator?
I watched your previous hearing. I think I'll just say I'd ask for an aye vote.
Do we have any hostile amendments for the senator? Would you like to? No? All right. Well, let's call the roll.
Do pass through appropriations. Huffman?
Aye.
Huffman, aye. Fuller? No. Fuller, no. Anderson? Anderson, no. Arambula? Arambula, aye. Berryhill? Berryhill, no. Blumenfield? Caballero? Caballero, aye. Delatorre? Fletcher? Fletcher, aye. Lowenthal? Lowenthal, aye. Salas? Salas, aye. Yamada? Yamada, aye.
That bill is out. Thank you, Senator Simidian.
Appreciate your support for a landmark measure, members.
It's an ocean mark, Senator Simidian.
Senator Hollingsworth, welcome. Is this a landmark or a simple bill?
It is both.
Thank you, Mr. Chairman, and members of the committee. This bill deserves some explanation. And while it doesn't go back to the time and where I was born, it does go back a few years. In 2006, I was approached by the operators of commercial hunting clubs who mentioned that there was a new interpretation of a regulation at the Department of Fish and Game where rather than charging $165 for the license for a commercial hunt club, if that hunt club was operating on parcels through a lease that were owned by other individuals, every one of those individuals that owned that property that was leasing to the commercial hunt club operator would have to sign up for a license as a commercial hunt club operator. Well, obviously, this wasn't the intent of the legislature, so I authored a bill that said, look, it's the commercial hunt club operator, it's not the owner of the land who needs to be licensed and follow the regulations. Seizing upon that opportunity after that bill passed, the Department of Fish and Game then said, well, we're going to have to charge an inspection fee for every one of these parcels, though, and they jacked the price up from $165 to several grand. The commercial hunt club operators obviously realized that they'd been had, and Mr. Berryhill and a subsequent attempt by myself have capped that and put in a schedule of fees. Mr. Berryhill's bill last year put in a schedule of fees that took it from what it was 4 years ago, $165, to if you have 10 or more, that it's $2,000. We think that enough is enough. Rewarding their bad behavior at $2,000 is beyond the pale, and basically we're saying, look, it doesn't take that much more to read a piece of paper and see how many parcels they're operating on. We should cap it at $1,000. They're getting a huge increase from 4 years ago in fees from $165 to $1,000, and it's really not that much more work. I know the department's going to say that this is a tremendous loss in fees for them, and in these budget times we shouldn't do it. I'd appeal to your sense of righteousness and let them know that they really haven't been good operators on this thing since the beginning of this whole saga. The point that will be made by some of the supporters of the bill, Mr. Ryan and others, is that we should recognize the fact that we have a severe shortage of fish and game wardens whose job it is to perform this action. And the best thing that could happen is if we could have more of these commercial hunt clubs come into compliance with a reasonable fee structure. Right now, there's a tremendous percentage of them that just are operating without this license. That's the bill, Mr. Chairman and members.
Thank you, Senator. Welcome.
Thank you. Good morning, Mr. Chair, members. Jason Ryan with the California Outdoor Heritage Alliance. We sponsored the bill last year with Assemblymember Berryhill. Senator Hollings did a good job telling you guys the back history on this, and I think he really hit it on the head in that it's not only about fairness, but it's also about trying to give the department adequate resources in order to fund their enforcement while not unnecessarily gouging these guys. If you look back at the enforcement rates in the past, the department really only collected about $30,000 total for all the hunt clubs in the state of California. And it's really because these clubs didn't quite understand that they were, in fact, running a commercial enterprise. We fully understand that if you're operating a commercial enterprise, you need to pay a fee, and it's a matter of addressing that fee and finding a fair fee. And really, it's all about compliance. And I think in last year's bill, the department did a really good job in going out and notifying landowners and other, hunt club operators and saying, hey, you guys really need to pay this fee. Here's where you can find the information. When they stopped hunters out in the field, they would ask them questions. Did you pay a fee to get onto the property? So they did some of their homework in trying to find out who, in fact, is operating a hunt club. So the department is going to see a tremendous increase in the amount of revenue that they're going to generate via last year's bill. If we eliminate the top fee by $1,000, we're really only going to affect about 10 properties, maybe 20 according to the analysis. So we're talking about a relatively small number of commercial operators that are going to see this reduced fee. However, it's completely fair and equitable. So we would just ask that you support the bill. Jason, thank you.
Welcome.
Matt Robinson with Fish and Game. I'm here in opposition to the bill.
Let me first ask if there's anyone else here in support. Seeing none, please go ahead, Mr. Robinson.
As was explained by Senator Hollingsworth as well as Jason, this is something that we've kind of been working on with both our law enforcement division as well as the hunting organizations to develop essentially a tiered fee structure that's currently in law. for about the last 3 to 4 years. And it all kind of started, as he mentioned, when, 536, I think was the bill in 2006 went into law that really, kind of for no one's fault, as far as we can track it back, put in the actual language in there that said the department shall assess a fee to each individual property, which was what was put in statute by the bill. We were in support of the measure back then in terms of allowing the property owner to take in all properties under his command and put them all in one license. I think the second thing that said we shall assess a fee for each one of those properties was kind of slipped by all of us at the time and was brought to our attention by one of our license and revenue folks when they went back and read the statute that following year and said, okay, now we've got a problem here. What are we going to do about it? Because there was, some of these groups own hundreds of properties, such as Wilderness Unlimited, which was going to make their hunt club license now something like $30,000. We agreed that was a little bit ridiculous and, in fact, did not charge them the full fee that year. So we started working on the current setup that's in law right now. We feel that it kind of needs more time to play out to actually see the true impacts. We had 73 folks apply and purchase a commercial hunting license last year. Our law enforcement division estimates there's well over 1,000 hunt clubs in California that should be licensed under this commercial license. Also, as the senator mentioned, it is a revenue loss for us. It's not a significant revenue loss.
A potential revenue loss.
Well,
because you're not getting the money yet.
True, and that's something we're not going to know until the end of the year.
I'll let you respond in a moment, Senator.
And again, it's all estimates right now. But again, it's, as I said earlier, we believe that it just needs some time, and it's probably going to be 2 to 3 years till we actually know the true impacts of the current tiered fee schedule for the hunt club.
Could we just? I know there's some questions from committee members. Could I just ask you, Mr. Robinson, to help us understand a little better the 10 to 20 licensed commercial hunt clubs that would be subject to the lower fee under this bill? Can you speak to sort of the size and the general character of those clubs?
I can say that the 10 to 20 is an estimate by the department based on warden contact in the field. Those clubs typically that are currently 11 or more properties are what we call for-profit clubs, meaning they charge money to make money. And sometimes that can be upwards of $300,000 to sit in duck blind for a season. Therefore, these guys may make millions of dollars a year. So we feel that the $2,000 for 11 or more properties, which these clubs typically encompass, is very reasonable.
Okay, thank you. Other witnesses in opposition?
Yes, thank you. Virginia Hanley with PAWPAC. And we're also in opposition, too, with a lot of the good points that you've already made. Thank you. And particularly the amount of money that comes in with the memberships that can offset any fees, and which does a very good job of offsetting those fees. I think the fees are minimal. I attend the Fish and Game Commission meetings. It's heartbreaking every time of hearing our lack of funds, our lack of wardens, our lack of enforcement. And so we should be taking care of the ones that are already here that are not even paying any fee, and put some resources into getting the current law enforced and not losing more money.
Thank you. Any other witnesses in opposition, support, otherwise? All right. I know, Ms. Caballero, you had a question?
Yes, actually, I had a comment more than a comment. I guess I had a comment more than a question. In really supported Mr. Berryhill's bill last year. I thought it made a lot of sense, and I appreciate the Fish and Game's response in regards to let us have a full year so that we can figure out what we're doing here. My concern is the unintended consequence, and I agree with you in regards to our need to beef up the warden, the number of wardens that we have, and make sure that we're really doing the enforcement that we need to do. My concern is with being fair and making sure that we're not setting up a system where we're encouraging people to not get the necessary permits, not do what they need to do because we've overburdened the price of operating a legitimate business. And so it's a terrible time to be taking away revenue, but I also recognize that it's the fair thing to do is to try to figure out a system that works. And I was not prepared to support this, but I'm persuaded by your history, the history that you recited, because it seems to me that when fees have jumped tremendously, that the best way to do is to back off and try to figure out what's the right thing to do, and to figure out how we're going to get. I mean, we really do have to get more wardens out there. There's no question about it. But on the backs of this particular sector, I don't feel that that's appropriate. So I'm prepared to support the bill, despite the fact that I do think that giving it a year would probably be the appropriate thing to do. I also am convinced, based on the history of how this has come about, that the right thing to do is to make it fair right now.
All right, Mr. Berryhill.
Thank you, Mr. Chairman. I guess my first comment is, when have we ever really been concerned about fairness here? I think,
and given that I just spoke, I'm going to add a caveat. Speak for yourself, Mr. Berryhill. Because you know what? That's been. I think I for well.
But I do want to thank Senator Hollingsworth. We have both been very engaged in this bill for the last few years of trying to make it fair and trying to make it equal. And really, the end game here is not to punish those folks that are trying to put land into these conservation easements and these hunting clubs. What we're trying to do is expand the program. That's always been the goal. I think that this is an absolute step in the right direction there, where you are giving a break of people that are really being overcharged. I think that this bill gives us an opportunity to expand to the smaller folks like myself that may want to put some land into conservation and wildlife management that will be good for the environment and good for the state of California. So I commend the senator for continuing on a bill that we've worked on for the last few years, and I'll certainly be backing that bill today.
Ms. Lowenthal, thanks.
Thank you. I find this a very interesting subject, since I don't have any hunting clubs down in Southern California.
I could fix that.
in Long Beach. But we do have not enough fish and game wardens, and we certainly don't have enough money in enforcement in Southern California. What are the actual costs for enforcement that we're talking about? We're talking about enforcement of clubs with multiple properties. And part of the reason that I'm asking is I know in other professions, for example, nursing homes, sometimes people are more willing to put money into fees for themselves in order to ensure that they are, all the rest of them are properly enforced, to get rid of the bad apples.
Right. I think that's a hard question to answer. I think the Fish and Game Department has had a tough time trying to answer that themselves, because as the representative from Fish and Game mentioned, because there was that provision in my bill 4 years ago that sort of left open the issue of, since we're going from $165 to something as yet undefined, we'll let the department define what it is. And they went way overboard, and Mr. Berryhill's bill had to come along to put a cap on it. We're trying to take that top tier off. Most of the time you would hear most game wardens say it's not a big deal. We go by once a year, we look at the property, and we basically sign off on it. The main issue with this bill is that we think it's probably going to bring more revenues than if you kept the current system, because we're not talking about the 10 or 20 big guys, the duck clubs in the Delta, for example, that have very expensive memberships. They're going to pay the $2,000. What we're talking about is the dozens and dozens, maybe a few hundred of the small clubs that are currently completely unlicensed. The department doesn't even know they're operating out there. They're going to come into compliance, because now your risk is still the same, but your ability to comply, your downside of paying the fee is much less. So they're going to pay the fee.
So it's your belief that these unlicensed clubs would readily pay $1,000 and not pay $2,000?
No, they're more likely to come in at the $1,000 or the other graduations under that than they are coming in at the $2,000. And they're looking at this as well, and they want to see that it's sort of been stopped, that it's been capped. They're looking at the last 4 or 5 years and saying, wait a minute, it's gone from all of a sudden we had this interpretation where everybody had to go out and get hunting licenses from the landowner on every property from what had been before that $165 to now this graduated scale of $2,000, or actually it was more than that before Mr. Berryhill's bill, to now once it stops and it stops somewhere and lands at around $1,000, I think they're going to say, okay, we understand now what the game is. $1,000 is our topside fee that we have to pay,
So
and they're going to come into the program.
If I could just ask one more question, what would be an example of enforcement? What is it that you're looking for? What do Fish and Game usually find when they go out to ensure that land is managed properly?
Well, you can go ahead, Matt. I'll follow up if you don't mind.
To both your questions, first and foremost, for the last few years, we've been doing basically, I would say that our wardens know where about 80% of the clubs are in the state. The problem is that the laws governing the hunt clubs were so confusing and hard to interpret that we kind of just gave everybody a free pass and said, I want you to know that we're working on reform to this stuff. When it comes down, we're going to give you about a year, and then we're going to come back and we're going to start citing you guys. And in our opinion, that's what's going to bring them into compliance, not the fees of the club, because the fees for the clubs, as Senator Hollingsworth pointed out, have been reduced pretty significantly. It went from $354 for a license for one property under pretty much 80% of the guys out there to $200. So we've chopped quite a bit off that, kind of in exchange for this tiered program to where we bring in more of the large property owners and make them pay their fair share. Basically, the wardens, like I said, have been kind of doing community outreach for the last few years, and starting this coming duck season, because basically this is when we're going to see the hunt club licenses start coming in, we're going to start enforcing this. So they'll be cited, and then they'll know I better get in compliance next year or else.
If I may, the challenge, at least from my perspective, that the department has had is most landowners, they don't realize that they're operating a commercial hunting club because it's not something where you walk through some pearly gates and you're in a hunt club. It's something where a landowner may charge a couple of $100s for an individual to access their property and, enjoy the 2,000 acres that they have and may, take a deer. But that payment constitutes a commercial hunting club. So you have many, many landowners that charge relatively very small access fees, if you will. They still have to pay this fee, and they have no knowledge of it because they're not, in their minds, operating a commercial hunting club. They're maybe a duck or a rice farmer who, has a blind or two on their property, and they're going to let individuals go out there for a very small fee. So as far as the top end tier, those guys do, in fact, yes, operate a commercial enterprise, and the department knows who they are, and it's a relatively small number of people. And like the senator said, it's about, achieving fairness. And if there's any segment within the Department of Fish and Game that pays their fair shares, it's hunters and it's guys operating commercial hunting clubs. No other entity actually pays fees for the most part. So this is the one segment that has been burdened tremendously, and we're more than happy to pay for game wards. We think they're the most important people. However, everybody can't continue to come to our well. Our well's tapped. We have so much extra in our well that it's continually rated. So if there's, I would suggest we look at other places to charge fees and, to assign that money to fish and game wardens, not so much hunters and these commercial operators. I think by passing this bill, we're achieving a degree of fairness, and I would hope that you vote yes.
Thank you, Mr. Ryan. I want to just ask a question because I too supported the Berryhill bill last year. I thought that was an appropriate adjustment to the unintended consequences, frankly, from your good work prior to that. I guess I'm troubled by the fact that a year later, after we've already made an adjustment to address all of the things that we've been hearing about here today, and we brought the price down for many of these clubs, we're sort of back at it again, and we're being asked, well, let's take it down even further. And it doesn't feel like an appropriate role for the legislature to be annually sort of sweetening to taste, the amount of fees, particularly when we haven't had a chance to let it play out and see, for example, what happens with some of these clubs that haven't yet come out of the shadows. I'm also troubled by the proposition that would require us to sort of take a leap of faith and to accept what looks like a clear hit in revenue to a department that already is a mile wide and an inch deep and can't afford enough wardens and isn't doing many of the things we'd ask of them. on the hope that a bunch of new clubs will see that lower price and come in and pay the fee and become legal. That just seems like a leap of faith that I'd have a hard time taking in any fiscal climate, but certainly not one where we have a department that's as cash-starved as ours is right now. So I'm happy to continue this debate. If members have questions or comments, that's sort of where I am and where I'll be voting. But Ms. Salas?
Well, the comment I had is that I was kind of taken back by the discussion of that they would come into these unlicensed duck clubs would come into compliance if we lowered the fee enough. And the comparison that I'd like to make is we as consumers, we're all required to pay the banking fees that the bank sets. And if we don't like it, we can choose not to bank with them, right? But you're going to be very sorely pressed to be able to find a bank that's not going to be, comparative. And so it just seems that this question of if we drop the fees enough, then people will become law-abiding is kind of shocking to me, right? I don't think that that's the way it should be. It's that if this is what the fee is in the state of California, then as good people, as duck club owners or the unprofessionals that let people on their land to do this, to me, we're sending a message as if we want to scoff the law, we can. Right. And so I think that what I want to see is that the changes that were made last year be given the opportunity to see if that's working before we further reduce a very strapped agency. So I can't support the bill today.
Madam Vice Chair.
Madam Chair.
If I may.
Pardon?
Madam Vice Chair, it's not the issue of the large clubs coming in. It's a dollars and cents issue. It's not an issue of they'll desire to comply. It's an issue of, as Mr. Ryan said, you've got hundreds, if not thousands, of people out there that they may charge a few $100 to a couple $1,000 for a family or a group of people to hunt on their property, and they're looking at it and saying, well, why would I do that and pay the $2,000? With a lower graduation and a lower cap on it, they're more likely to come in and say, okay, I understand I'm a commercial hunting operation because I charge these 5 people to come on my property a couple of times a year, and that $5,000 that I get for it is worth coming in and being in compliant by paying the $1,000. That's the difference there. It's not I think characterized the way that you're characterizing it, Assemblymember Salas. And again, I would remind you that this isn't revenue that the department should be getting because they misinterpreted my bill from 2006. They were getting $165 for if somebody had 50 pieces of property. If they had 500 pieces of property, they were getting $165. And they put my bill through that had this language in it, and all of a sudden they jacked it up way beyond the $2,000 that Mr. Berryhill's bill capped it at. They made it tens of thousands. And we're just trying to say, look, you're getting an increase from $165 4 years ago to an increase to now $1,000. That's enough.
Thank you, Madam Vice Chair and Madam Chair. Thank you, Senator. What this bill does, if I'm understanding it correctly, is really you're removing that top tier and making all clubs 6 or more properties the same flat fee. So in essence, there's no upper limit. And in my mind, or the upper limit is now $1,000 for 6 properties or more. It just seems to me that when you have more, you should pay more. I mean, that's my theory on life. And these past 2 presentations, and with all due respect to my colleagues on the other side of the aisle, in a cash-starved state and revenue climate that we're facing, both the previous presentation and current presentation is asking the legislature to act upon reducing the amount of revenue that we have available to do increasingly complex and difficult kinds of jobs. And I just thematically, am unable to support when there's no upper limit, or the new upper limit is such a lower limit now that and I'm speaking as a representative of the Delta, where many clubs find their home. I also represent the Yolo Basin and the Suisun Marsh. So it's not that I don't have relationships and understanding of some of the challenges that are faced by responsible owners, but I just find that the loss in revenue and the fact that we've had some of our DFG wardens come to speak with us about the difficulties that they're facing, it's almost like saying that we're going to hope that, and similar to what Assemblymember Salas just raised, hope that those who are skirting the law now by sweetening this pot or lowering the upper limit, they're going to suddenly rush to comply. I would rather see the fees continue in place, at least for some period of time, until we find out whether or not increased supports for DFG will enable them to bring these non-conforming club owners or property owners into compliance. So I regret that I will not be able to support the bill today. Maybe if it comes back in some other form, or there is some other, you're taking from 6 to 11, that's 5 properties, lowering the limit from 11 to 6. And it just seems that that's, almost a doubling of what the lower limit, the advantage to those who would have more properties. It just doesn't, it's counterintuitive to me. So that's just where I am. Thank you.
Mr. Berryhill.
Yeah, thank you. Just one last quick comment. Mr. Hollingsworth, this seems to me that we're just trying to widen a base here so we bring in more income. I mean, instead of punishing those that are on the upper tier now, we're merely trying to expand a base so we can have more money for Fish and Game. There's so many folks out there that are sitting right there on the cusp, and why should they jump into any program if they don't have to, especially if it's way too expensive. What we're trying to do here, folks, is simply expand a program so we have more revenues coming in the long run so we can hire more Fish and Game officials. So I think that is the intent of this bill. That's why I am certainly going to be backing it today, and I urge an aye vote.
Assemblymember Caballero.
Yeah, my feeling is we probably could beat this into the ground, but I guess there were some questions that were asked in regards to the kinds of oversight that the Fish and Game does when they go on to these clubs. And what's always been compelling to me is to look at what does it cost, and then how is the fee rationally related. And frankly, we have this tiered system because of the able presentation of Mr. Berryhill last year. And I haven't been convinced that the cost of the oversight for the number of properties. I mean, I understand how we ended up with the properties system. And given that, I haven't been convinced that the cost of oversight for these clubs goes up if you go from 6 properties to 11 properties significantly, that would warrant that. So to me, again, I get back to this whole idea of, in reality, we really don't charge. What we try to do is to figure out what is it that it's going to cost us. What does it cost us to do this license, or what does it cost us to process this particular application? And we want some relationship to it. And the challenge is that I think at a time when the economy is so bad, to then start adding other things on because we're not willing to fund it. I mean, there's a lot of things that the wardens do that are not part of their duties, going to these duck clubs, and we're just not funding them. That's the bottom line, and we're not funding them because we don't have the resources, and we're making these difficult cuts everywhere. So I think it's the whole idea of hopefully we get more coming in, more clubs coming online, and it'll help. That's all well and good, but I really think the real issue is, what does it cost us to do oversight of these clubs? it has gone up significantly over the past number of years. That's the history that was compelling to me, and that's one of the reasons that I'm willing to support it at this time. And I really think we need to. Mr. Bearhill, you may feel like sometimes we don't do things that are very fair around here, and that's probably true, but I try to look at it on a basis of fairness. Are we generating revenue different than what we generated 4 years ago? And I think the answer is yes, and it's fairly significant. And has the cost gone up because of the kind of oversight that we're doing? And I feel compelled to say no, we're not really. So that's the reason I'm going to support the bill.
Member Bloomfield.
Well, I figured I might as well add my voice to this. And although I regret I'm not going to be able to support this bill. The argument about compliance, lowering the fees to get compliance, that doesn't sit well with me. I can't go there. But the argument about lowering fees to get more money is very interesting, and I'd like to see how that, lowering fees to get more fees, if that could be a compelling argument, I'd like to see how that plays out. I'm not convinced that that's the case, or I haven't seen the evidence to that effect. And lowering fees to just get more clubs is not sort of a compelling public policy to me. So that doesn't get the check mark for me. So of those three, I said that the only one that at least is interesting is about lowering fees to get more revenues, and I haven't seen that play out. And just as the budget chair and someone who's just steeped in all the budget stuff right now, I can't in good conscience lower this kind of a fee without really strong evidence that it's going to be raising more revenue.
Madam Vice Chair, if I may,
yes.
I'm sorry that you came in late in the discussion. That was one point that we've spent quite a bit of time on, but it is a minor point. The main point of this bill is that they had one fee for no matter how many parcels 4 years ago of $165. They're now getting a graduated fee that goes up to $2,000. So from 4 years, they've gone from $165 to $2,000. That was scaling it back from them taking advantage of a line in my bill 4 years ago that said that they would set the fee based on the number of parcels, and they went to tens of thousands of dollars, or $10,000, $13,000, whatever it was. So basically what we're talking about is the difference, as Assemblymember Caballero has mentioned, the difference between, does it really cost the department $1,000 to inspect the 5 more properties in that increment between 6 and 11? No, it doesn't. And so we'd like to cap that at $1,000. They're still getting, from 4 years ago, an increase from $165 to $1,000.
I mean, I get follow up on this.
Yes.
Responding. I guess it also depends on how you define what fees are used for, and is that the only legitimate use of that fee, or does the department have a broader use in terms of hunting and regulation? And I mean, I tend to look at those fees. Obviously, there has to be a strong nexus, but not so narrowly as defined as this fee has to just pay for that inspection, but it pays for a myriad of services that support the industry.
Hopefully it only pays for the inspection and the enforcement of that program, or it's unconstitutional. It's a general tax. Otherwise, it's not a fee.
Well, that's what I'm saying. Is the definition? I'm saying obviously you can't go past the Sinclair nexus, but I think it's often more broad than just paying, the gas and the time of that person to inspect that facility. But it's actually, what is that inspection all about? What is hunting all about? And what does the department do? And what are the fees that these inspections go to? So I tend to look at that a little bit more broadly, and within the constitutionality, look at it a little bit more broadly.
I just have one question, and then maybe we'll see if we have a motion. But what was the revenue when it was $165, and what is it now?
I wanted to just touch on that. I need to go back and look at it, but I don't believe the fee was $165 4 years ago. It's $354 last year, and we have basically we can raise it with the cost of living every year, which is typically 1% to 2%. So it's probably about $300 4 years ago, right around there is my guess.
What's the total revenue? Is there net increase over before the bill?
I'm using 165 because that's what the analysis on ours says was the.
In other words, are we making significantly more money now than we were?
We have no idea. We do not know until the end of this year and probably not for 3 years to get actual numbers.
But we think we are making significantly more.
If we were to go out and enforce, as we plan on doing, all of those clubs that haven't been in compliance in years past, yes, we should make.
That's not the question. Is the total revenue raised is significantly more than it was?
Correct.
Correct.
Depends on how you look at it.
Okay, and then number two was you
it's
earlier
less for
earlier
single
in,
property owners.
Earlier in your testimony, you said that there was like a fee that was at the higher end of the tier that was just so expensive that you didn't enforce it because it was out of line.
No, what had happened was with the Hollingsworth bill in 06, we had essentially caught ourselves on it. We looked at it and said, this is what statute says. Do we or do we not enforce this? Because as I pointed out, there's a group called Wilderness Unlimited, and they're really the ones that made the initial complaint about it. And they own hundreds of properties throughout the state. So at $354 times X amount of properties, they were looking at something like $33,000. We realized that's ridiculous. That was not the intention of Mr. Hollingsworth's bill, and we basically let them go with the year before where they paid one fee for all those properties.
Okay, so this bill would fix that.
That's what Mr. Berryhill's bill did last year, was to kind of remedy that situation. And then, like I said, with meeting with hunting groups and our enforcement branch, the tier system kind of came about and had been kind of in the works for a few years after the Hollingsworth bill had gone through. And kind of where we're at now is what we decided would be a fair scale.
Okay, so I guess.
Madam Vice Chair, if I may, just from the committee analysis from the Senate Natural Resources and Water, I was looking for that figure. The Democrat analysis on the Senate side says that this would probably cost the department about $10,000 a year.
Okay, do we have, I think we're at the end, is motion? We have a motion. Do we have a second? Second. We have a motion and a second. Should we call the roll? Oh, would you like to close? I'm sorry.
I just would urge an aye vote. This has not received any no votes until this point, unfortunately. It's been 34-0 in the Senate and 9-0 in appropriations on the Senate side and bipartisan support.
Do pass to appropriations. Huffman. Fuller.
Aye.
Fuller, aye. Anderson. Aye. Anderson, aye. Arambula. No. Arambula, no. Berryhill. Aye. Berryhill, aye. Blumenfield. No. Blumenfield, no. Caballero. Aye. Caballero, aye. Delatorre. Fletcher. Aye. Fletcher, aye. Lowenthal. No. Lowenthal, no. Salas.
Aye. No. Excuse me, no.
Salas, no. Yamada. No. Yamada, no.
Bill's on call. And we have consent calendar now. Do I have a motion? Motion? Second. Call the roll.
SB 1058, do pass consent with amendments to appropriations. Huffman. Fuller.
Aye.
Fuller, aye. Anderson. Aye. Anderson, aye. Arambula. Aye. Arambula, aye. Berryhill. Aye. Berryhill, aye. Blumenfield. Aye. Blumenfield, aye. Caballero. Aye. Caballero, aye. Delatorre. Fletcher. Aye. Fletcher, aye. Lowenthal. Aye. Lowenthal, aye. Salas. Salas, aye. Yamada. Yamada, aye. That's out.
Okay, we'll lift the call.
Item number 2, SB 889, Onnested. Item number 2, SB 889, Onnested. Do pass with amendments to appropriations. The current vote is 6-4. Chairman recommends aye. Absent members, Blumenfield. Aye. Blumenfield, aye. Delatorre. That bill is out.
Oh, yeah.
It's Anstead.
As amended.
Ansted's bill is out as amended.
Item number 5, SB 1173, Wolk, do pass to Environmental Safety and Toxic Materials Committee. Current vote is 5-3. Absent members, the chairman recommends aye. Absent members, Anderson? No. Anderson, no. Blumenfield? Aye. Blumenfield, aye. Delatorre? That was item 5. Delatorre? Lowenthal? Aye. Lowenthal, aye. That bill is out. Item number 3, SB 904, Hollingsworth. Do pass to appropriations. Absent members, Huffman? No. Huffman, no. Delatorre?
That measure fails.
Can we have reconsideration on that?
Certainly, yeah. And without objection, reconsideration on Hollingsworth.
Is everything, is it done? Yeah, everything is out.
And everybody's on?
We'll add on.
There's some add-ons.
Okay. Why don't we just go through quickly each bill and we'll call the absent members and we don't have too many bills to cover.
Yeah.
Item number 1, Blumenfield. Item number 1, Blumenfield.
Bob Simidian, Fishing Gear
SB
Simidian.
21. Blumenfield, aye. Delatorre. Item number 2, SB 889, Onnested. Delatorre. Item number 3, 904, Hollingsworth. Delatorre. Item number 4, SB 1058, Harmon. That was on consent with amendments. Huffman?
Aye.
Huffman, aye. Delatorre. Item number 5, 1173, Wolk. Delatorre.
Were you, well, there were
I have
2
you on
Wolk
that
bills.
one. You added on to that one when we lifted the call.
Did I add it on that one as well?
Yes, you did.
Okay.
We're just stuck at 6.
Item number 6, 1303, Wolk. Anderson? No. Anderson, no.
Oh, I'm sorry.
I think you wanted to be yes.
I'm an
Yeah.
aye.
Anderson, aye.
Yeah, thank you very much.
Blumenfield? Aye. Blumenfield, aye. Delatorre? Lowenthal? Aye. Lowenthal, aye.
All right. This committee is adjourned. Thanks, everybody.